Andy Savage has a lot to say when it comes to the tragedy at Mother Emanuel AME Church and the shooting of Walter Scott. In this edition of Quintin's Close-Ups, I sit down with him one-on-one. And be sure to download the free Quintin's Close-Ups app in your Google Play or Apple stores. But let me go to Michael Slager. Obviously, you've been around him since last year.
Yes.
And obviously, there was a mistrial declared in December, and obviously we know his future might be up in the air.
Yes.
What is your relationship with him right now as we speak?
So, you know, those two tragedies of the spring of 2015, I mean, who else has ever experienced being in the middle of such monumental events that relate to one strictly race, but the other with race and police, quote, misconduct. I didn't know Michael, much unlike the Emanuel case where I knew those people and had known them for years and they were part of my crew, right? I mean, it wasn't, I didn't go bowling with them, but,
right.
You know, I mean, we were intimately familiar.
Right.
And when I say that, I don't mean just with Felicia, but with her sisters. And, you know, it was not race, but an integrated relationship I had with them as community members. Michael Slager's relationship to me was he was a law enforcement officer in our community. And I did not know him. I never had a case with him. I didn't know anything about him other than he wore a badge. And Cheryl and I woke up one morning and our bedroom TV was on. I'm sure what channel you with? Yeah, it was channel 4. And we saw this video and I said, oh my God, I can't believe that. And you know, I was angry that somebody would do what I saw on that video to another human being. And Cheryl, who you know, is, you know, we're the mirror of each other. And that was the topic of early morning conversation that day. Little did I know that his attorney, who was hired by the Police Benevolence Association, saw the same video. And you recall that the attorney who had previously given a press release about this was a misunderstanding, without knowing anything about the case, issues a press release, stands up and quits. And then the PBA quit. So to Andy, doing what I do and have done for a long time, and my relationship with law enforcement, which has always been very positive for all those years. Yes, there are situations that are not good, but I have great admiration for anyone in law enforcement. I met with Don and Scott and Cheryl and Heather and I said, you understand what happened, and I feel that we got to help this person because everybody had picked up a stone and was throwing hard balls. And I said, I've seen the same video you've seen and I don't like it, but nobody has said anything about what happened from the stop until the shooting. There was a gap there, and it was immediately recognizable by all of us, although I think that the media missed that. And so the narrative that came out at that time, which rightfully based on that narrative should have been one of animosity and anger, was that a white cop stopped a black man driving a vehicle in North Charleston for a light bulb that was out. And the African-American man ran from the scene and got shot in the back. Well, that's mostly true, but it's false because it leaves out all the intervening events that took place from the time of the run until the time of the shooting. So, you know, it took us and our investigators, let me tell you about that for a minute too. We interviewed 55 expert witnesses in that case, 55. I've never even interviewed that many in my career. But for this case, We had to get experts in video, we had to get experts in audio, we had to get experts in the use of lethal force, we had to get experts in the use of tasers, we had to get experts in medical examinations and psychiatric examinations, and on and on and on and on and on. I think we got the very best experts in the nation. We had experts from New York, from Toronto, Canada, from Seattle, Washington, from Portland, Oregon, from Houston, Texas, from Phoenix, Arizona. We went all over looking for the very best because it was such a burdensome case. That's what I said. I've worked on it every day. It was such a monumental hill to climb, not just the facts of the case, but the understanding of what happened by the American public, because they were given such a narrow vision of this clear video of 10 seconds where somebody's running away and he's firing 7 or 8 shots at him. So Michael Slager, as I said, I didn't know him, and I wasn't overly concerned about asking for a bond. I thought that that was inappropriate, and I really didn't want to comment on the case in the beginning out of respect for the Scott family. I did not know the Scott family, but I knew of the Scott family, ironically, through some of the people at Emanuel. And I have great respect for his mother, who has a wonderful reputation in the community for kindness and caring and understanding and peacefulness. I had no knowledge of her sons, but I did have knowledge of her. And out of respect, I didn't want to say anything immediately about the events of what went on. But my responsibility as a lawyer was to Michael Slager. So I, deliberative in fashion, went through every potential fact of the case to develop it to see if there was more to this story. And of course there was. And you know, Quintin, one of the things that troubled me about that case was he got caught in this tornado of misconduct by police officers throughout the country, mostly in a racial situation in which a black man was killed. And because so much of that was going on, from Florida to Milwaukee to Chicago to Staten Island, New York, to Baton Rouge, Louisiana, and you name the city and I'll tell you the case, he then became just thrown in the mix, right? So how the national view of the Slager case was based through the prism of all these other cases. And our responsibility was to pick out our case, the facts of our case, and make sure that we individualized the legal judgment of his actions by the facts in his case and not by all the surrounding other police misconduct cases. And, you know, as we picked through it, the fact that he was charged with murder sort of outraged me, that this was not a murder case at all. There was no hatred or animosity. So a murder case requires a evil thought and a pre-firing of the weapon condition in the mind that says, I want to kill you, for whatever reason, right? There's no evidence of that in this case. This was a very routine day, and I can get into that, I think, in another hour. But there was nothing to indicate the elements of murder. And then you go to manslaughter, and there was no indication. You've seen the video, you've heard his voice. There was no indication of anger. It was professional from the beginning to the end. So in state court, that was just never something that, as a lawyer of long standing in this community, I would ever recommend to a client for him to plead responsibility for either murder or manslaughter. We did try to reach a compromise in the state case that was rejected by the solicitor. But here's the problem I have with the case, and he's pled guilty now, so I'm not speaking against Michael, but I'm talking legally as his attorney. They're in this fight after a 200-yard run, and there's a discharge of the taser by prongs on 2 occasions, and then there was confrontation, and I believe that the taser was removed from Slager. As he called for help, he only had one hand. Scott grabbed the taser from him, his DNA is all over it. There were fabric disturbances in Slager's shirt consistent with being hit by the taser. So in my mind, I'm absolutely positive that there was a physical knockdown fight. The video will show you, I'll be glad to show you, where they're both on the ground fighting each other. In the beginning, Slager's on top. Towards the end, Scott gets the advantage of him. And they're like this. Slager's trying to hold on to him 1.4 seconds before the first shot hits Scott. That's not a criminal case. If Slager had shot Scott on the ground, it would not have been. It wouldn't even have been an administrative case. He would have been. Everybody would have agreed he was within his rights when he was attacked by Scott. If he shot him on the ground, nobody would register a complaint. The first shot is not a criminal case because he was being attacked. Remember, they all said no, he wasn't coming at him. Well, look at the video and look at it when you break it down to single shots. They're toe-to-toe. Scott's aggressively at him, face-to-face, toe-to-toe, in an aggressive stance. It's on the video. People just never took that shot and broke it down into single shots, and they're touching each other, and you see him reaching for his weapon, and you see him shooting 1.49 seconds. In the trial, I took a piece of paper, and I held it at chest height, and I dropped it. And it took longer for that paper to hit the floor than it did from the time they were touching each other to Scott received the first shot. I don't have any problem with that legally. Could he have done something else? Yes, he could have done something else. But that's us, 2 years later, analyzing the situation and what could he have done. But remember, Slager didn't know whether he was armed or not. All he knew that he was being very aggressive. He attacked him physically. He knew Slager was armed with a taser. He knew he was armed with a gun. Yet he still attacked him. So what would I have thought? I would have thought the only reason he's attacking me is because he's got an equalizer. So even when they broke off, I didn't have a problem with that as his lawyer or as his lawyer analyzing the case, because he could have been turning to gain a tactical advantage to reach into his waistband and take a weapon out and fire it at him. That's a very reasonable perspective given that situation. And I don't have any problem with that. Where it started to get blurry for me was as that distance increased. And Scott did not make any offensive moves. In other words, as he ran away, I'd be okay if he reached in his waistband. Or I'd be okay if he got behind a tree. Or he made some additional movement that would give you an indication that he's going to return to an offensive position.
Okay.
But as he ran, I don't know where, but at some point in that distancing, the use of lethal force became excessive. Because while it was less than 1.5 seconds before the first shot, there was time and distance before the last shot. And you remember the last shot, it was bam, 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 bam. Still not murder, still not manslaughter, but was it excessive? I reached the conclusion and recommended to the client that it was excessive at that point. So in federal court, he's not charged with murder. He's not charged with manslaughter. He's charged with use of excessive force. And it was my opinion and my recommendation to Michael that he should accept responsibility for the use of excessive force. Now, The government interprets the use of excessive force in Slager's case as being murder or being manslaughter. But Judge Norton, who's the sentencing judge, will have to evaluate the facts of the case. We agree that what happened to Mr. Scott was excessive. So now Judge Norton has to scratch away all the hoopla, get down to the facts of what happened, how it happened, who's responsible and whatnot. It was the excessive force used under the conditions of murder, or was it reckless? And we believe it's on the reckless end of that, the negligence end of that, that it was inappropriate use of force, but it certainly wasn't murder. And so those will be the issues that Judge Norton will have to sift through the facts and make a determination on. That's why I think you can predict and expect a rather lengthy sentencing proceeding. So many people are used to the state system where it's a 5-minute process. You know, you go to trial, you get out, the judge says, well, I sentence you to life, or I sentence you to 30 years. Federal court's much different than that. They look at Slager's background. They look at his education. They look at his training. They look at his upbringing. They look at his academic status. They look at his financial status. They look at his psychological status. They do a really intensive job. You know, it's already been 2 months.
Right.
So they'll do an exhaustive job of trying to understand the facts of the case, but much differently than in state court, they try to understand the facts of who the people are that were involved in this. And so that's what they're doing now, and I expect that maybe sometime in August we'll have a hearing. I would expect a 2-day to 3-day hearing. We intend to present a lot of testimony that I have now been telling the public about in terms of the full narrative of the events. A lot of it came out at trial. You know, it's something that no one ever anticipated, and it's an action that nobody is happy about, and there's been a lot of tears and regret on both sides. I think that the solicitor's office in particular saw this as a political opportunity, as sometimes happens when you have elected officials, that the tsunami, if you will, of anti-Slager media, that wave was ridden by the solicitor in their choice of charges. This case could have easily been resolved 2 years ago with the solicitor's office, with an acceptance of responsibility by Mr. Slager, which he was always willing to do, and always regretted the death of Walter Scott, and wanted to make amends to Mrs. Scott, and to meet with her and tell her how sorry he was for what happened that day, and explain to her not an excuse for what he did, but an explanation of why he did what he did. And, you know, we spent a considerable amount of time with the solicitor. You know, the solicitor and 4 of her top deputies tried that case. Think about that. When was the last time you saw that? Right? So you see the importance that they put on the case. And, you know, this juxtaposition of federal, state, who's going to go to the dance first, you know, and get all the publicity and all the notoriety and everything else. All that was just so unnecessary, and unnecessary for this community to have to go through, when acceptability could have been determined in the summer of 2015. But it was not a murder case, and I would never, ever, ever have stood next to Michael Slager accepting responsibility for the murder of Walter Scott or the manslaughter of Walter Scott, because that's not what happened. And I know I'm an advocate, but I'm trying to be as reasoned and step back and look at it. Quintin, Michael didn't pay a penny for his defense. His experts alone cost over $650,000. in a quest for justice. That's the only reason we did it.
Okay.
All right? He didn't pay me a penny. He didn't pay any of our experts a penny. He was shafted by his lawyer. He was shafted by the Police Benevolence Association, who, by the way, we beat the pants off when we filed suit against them. And we have an ongoing suit against them still for all the other members of that organization. His chief of police stood up on television and said, I threw up when I saw the video. Yeah, I threw up when I saw the video too. But you know what, Chief? I also looked into it to see what happened besides the video and what the video didn't show. And then you had Mark Crow, whatever his name is, the guy, the sled guy, the director who's supposed to be a lawyer, and he stands up and gives a big headline to the press. Slager never, refused to cooperate. Slager gave 3 separate statements within 90 minutes of the incident. And the head of SLED has a big headline that says he refused to cooperate. And it was just an awful battering by everybody jumping on the wagon and mob. It really was mob justice. And the mobsters included were the chief of police in North Charleston. The mobster included was the director of SLED. The mob was included the solicitor of the Ninth Judicial Circuit and her deputies that were involved in the case. I can understand non-lawyers with mob mentality, even chiefs of police, right? I have no appreciation for lawyers who are trained in law, who let emotion and political considerations override legal decisions. And, there's much of a legal tragedy in the Slager case as there was the death of Walter Scott. I know I went on way too long. But
no worries.
As you know, I'm pretty wired up about both these cases.
I know you are. And I thank you for this interview. I really appreciate it, Andy.
I always appreciate seeing you, Quintin.
Anytime.
Someday we got to tell the audience our relationship and
Sure.
how far back we go.
Absolutely.
You come to Channel 5 as an 11-year-old because you wanted Coca-Cola, right?
Oh, yeah.
So you're always a news fanatic, and
Yes.
I'm very proud of your success.
Thank you.
I congratulate you on your relationship with Channel 4.
Thank you.
It speaks well of them to understand how important you are to our community. And for a little while, Quintin, Dan Crossy and I had that show.
Right.
Beyond the Headlines.
Right. You got the Emmy sitting up there?
Yeah, that's what our community needs. We don't need a minute 20 newscast. We need to go beyond the headlines.
Sure.
And I think the Post and Courier really does a great job, and I'm glad they've won all these Pulitzers and other prizes that they've won recently. But the Slager case is the perfect example. When you give an electronic, visual, and audio-based newscast for a minute and 20 seconds, which most news stories are, I believe, you cannot possibly explain to the public, give them a full insight into what happened. And I would hope that the media, and I've talked to the New York Times, I've talked to the Washington Post and the Charlotte Observer and the State and the Post and Courier, about how they have a responsibility. Supposing there was a reaction to the non-verdict in the Slager trial, in which there was eruptions of activism in the community. The public, based on what they knew from the media, they'd say, well, that guy was guilty as can be. I understand why people are doing that. So the media really has an obligation to the public to tell a complete narrative of the events and be balanced in what they did. And I challenge you, as part of the, what is that guy in Washington I don't like, call it, the mainstream media, go back and evaluate. I challenge the journalism school at the University of South Carolina, or any of Syracuse or Columbia, the best of the best, right? Go back and analyze the media's role in this case, because it's contained and it's not exhaustive research to do, and to see how biased and It wasn't biased in the sense of false news, as that guy would call it, right? Fake facts. But it was an editorializing by the choice of what facts to use. You know, you never heard that Scott's DNA was all over the taser. You never heard from the SLED that he had cocaine and alcohol in his system. You never heard from SLED that if the radio report had come back to Slager that morning, it would have said he's believed to be armed and dangerous and not to do anything until backup arrives. The media has never said that of the 7 patrol officers working that bureau that morning, only 1 was on duty, that the sergeant wasn't present and no other police officers were on duty at 9:30 that morning, so that Slager was all alone. And why is that important? It's important because if there were 2 officers there, their physical presence is an intimidation. And the chances of Scott running, if there were 2 people standing there, would have been pretty slim. Because one would have stayed at the car and the other one would have gone back to do the computer research on who he was. So there were so many things that nobody else has taken responsibility for in this case. Did you know that 16 months after that incident that the North Charleston Police Department, the chief of police, 16 months later, put out a order for mandatory minimum staffing? That means the North Charleston Police Department, until the summer of 2016, if one person showed up for work and there should have been 10, nobody called in overtime, nobody called in other people. They just did the best they can with the resources they had. To me, it's a community. I know I'm going on. But to me, it's a community problem on public safety. But it's also a safety matter for the employees of North Charleston. Are you kidding me? You're going to put one officer out there to ensure peace in the whole community and have him act on his own? Well, what happens when that happens? It's just like this case. When things get out of control, when the officer can't control, he starts elevating the type of force he uses. When I say, Quintin, sit down, you don't sit down, and I push you, and you sit down, but then you jump right back up. Then I take my taser out and I zap you with the taser, and you still are acting foolishly and aggressively towards me. What's the next step? But if there were 2 officers there, and I tell you to sit down, and you don't sit down, there are 2 people ensuring that you sit down. So you never get to the taser. You never get to the lethal force. So actually, police presence helps the citizens to maintain a level of communication and resolution of problems that otherwise wouldn't have happened. And in this case, you had one cop on his own, 200-yard foot chase, fight on the ground, calls for help, nobody's there, he's getting the tar beat out of him, he doesn't know whether the other guy has the gun or not, or why he's being so aggressive. And what do we have? The destruction of 2 families.
Andy Savage, thank you again for this interview. I really appreciate this.
Always good to see you, Quintin.
Yeah, likewise, I appreciate this.